for the day, starting with 25 seconds of time. Read the slides at all. And special majority is achieved whenever the removal impeached. Of course, moving on to the next question. Absolutely incorrect statement. Then, removal process of judge of Supreme Court and High Court is the same. Yes, it is the same. Salaries, allowances, and pensions of judges of both Supreme Court and High Courts are charged. Tell me, what's the problem here? What is not charged on CFI? The salary of High Court judges is charged on CFS. Okay, so this is wrong. The advisory jurisdiction of the Supreme Court has to be presided over by minimum 5 judges is, of course, correct. 2 are right, 2 are wrong. Only 2. Moving on to question number 3. Which schedule? Third schedule. Second schedule is for the salaries. One is wrong. Any retired judge of Supreme Court of India can be called back to sit and act as a Supreme Court judge by the Chief Justice of India with prior permission of the President of India is absolutely correct. This is Article 128. Right? So 2 is correct. B, 2 only. Moving on to the fourth question. Court of Record. Article 129 for Supreme Court. Judgments are recorded for perpetual memory. They are of evidentiary value. They become facts. And Supreme Court has a power to punish for contempt of court is also correct. Both are correct. C, both 1 and 2. And last question for the day, ending on a nice winning note, means but then very few of you mark D as the answer. This means you have not seen this also and mark the wrong answer also. Double trouble. Right? Anyway, the High Court judges on retirement are debarred from practicing in the Supreme Court. Yes or no? Of course it is wrong. They're allowed to practice in the Supreme Court. Right? Then, violation of the Constitution is the only ground for removal. No. Violation of the Constitution is the ground for removal of the President of India. For the High Court and Supreme Court judges, the ground of removal is misbehavior or incapacity. This is also wrong. Both are wrong. C is the answer. Are we clear? Vijay Raghavan, no. Article 124 clause 7 does not work for them because they are not made judges. They are only attending the court. Okay? That's it. We are done for today. And now let's move on to judicial activism. Yes, guys. Don't be excited. Leaderboard. Oh, quite a few of you. Nikhil, Dudekula, Peti Rajulu, Rashi, Neha, Poonam, Rahul, Jayashri, Karthik, Sushant, Govind Rajulu, Dinesh, Priyadarshini, Harsh, Bhavik. 15 toppers. What is this whole concept of judicial act? It's a philosophy. Think of it as a philosophy. compelsion, etc. Right? And there are plenty of examples on activism. In fact, today we'll start our discussion on the examples only of activism. Right? So, firstly, some recent examples. Say in the case of Kerala. In this particular case, the Kerala High Court gave a statement stating that the people need to be protected from these ferocious dogs on the streets. So, what exactly has been happening across the country is that because people are emotional, so what they will do is that they will start feeding stray dogs, and these stray dogs become territorial, become aggressive, and we have seen cases of kids on the streets being attacked, etc. So a very good example was of Kerala High Court saying that state, please ensure that these ferocious street dogs need to be restrained, and people's life, the protection of it is your responsibility, right? Or in various cases, you will see that the high courts uh, ask the government to provide compensation to acid attack victims, like recently in the case of Uttarakhand High Court, where the High Court asked the government to not only pay compensation of 35 lakh rupees, but also to provide vocational training to the victim of acid attack. Okay? Then, when it comes to no, sometimes treatment of rare diseases, because a rare disease may not impact everybody. So when it comes to treatment of rare diseases, we found that the government quite logically gave this statement. The court, Delhi High Court, quite logically said that government of India, let's do one thing. Because you may not view these handful of people as a viable vote bank, does not mean that the state should not take any steps to treat these rare diseases. If funding is a problem, why don't you go for crowdfunding? Meaning, ask people to donate. And that money can be used in research and development for the treatment of rare diseases. See, giving advice to government on how to raise funds. Policy matters. Or in the state of Telangana, what had happened was that Telangana government cancelled 19 lakh ration cards without even conducting on-field verification. The idea has been the case that in our country, lot of people do get all these ration cards wrongly, right? And the very famous case where somebody photographed this person in Punjab who came on a BMW to take his food grains from the ration shop, the 1, 2, 3 rupees per kg food grains meant for the poor and deprived, coming in a BMW to take that ration. So the Telangana government cancelled 19 lakh ration cards. That's the problem. The court said, without conducting any verification, why have you cancelled those ration cards? Come on. Firstly, conduct on-field verification to establish the fact that the ration card has been obtained by an undeserving person, and then only cancel those ration cards. And also, a very innovative step in the direction of, say, environmental protection. So you have these great Indian bustards. Spelling is very important, please. Don't make a mess of the spelling. So these great Indian bustards, these birds, what happens is that when, if you look at all these areas in, say, Gujarat, or say in the case of Rajasthan, they are trying to generate revenue through, they are trying to generate electricity through what? Solar energy, wind energy, etc. And to transmit the electricity, they use these transmission lines, the electric poles that you see in your cities. Now, in these desert type areas, these birds which fly are not able to sight the transmission lines. And then when they come very close to the transmission line, they are unable to change their course or path, and they collide and they die. So the Supreme Court directed the Gujarat and the Rajasthan governments to install bird diverters. It's a plastic box installed on the transmission line, just placed there. It's hanging there. Now the bird can see from far off that, oh, there is something there, and then they can change their course of flight. So these are things that the courts instruct the governments, right? Or a very interesting thing which happened recently was also in the case of Tamil Nadu. In the case of Tamil Nadu, one Senthil Balaji, he was made the minister without portfolio. I mean, he was a minister, but then because of the allegations and because of his custody, etc., the ministry was taken away from him, but the portfolio, but he was still a minister. Minister without any portfolio. No ministry allocated to him, but still being called a minister. Imagine today there is somebody who is a minister, and then he has some task to perform. The task is taken away, and still he is called a minister, getting all the perks, benefits, etc. It makes no sense. And the Madras High Court uh, asked the CM to take a call immediately on this, right? The S. Ramachandran case of 2023, and rightfully said that the founding fathers of our constitution may not have comprehended the corrosion of good and clean governance to an extent that a person would be retained as a minister without any ministry, that too while in custody, right? Very strange, right? So the courts also give these statements where they try to keep a check on any undue discretion of the governments. These are all steps taken in the recent times, right? There are more such examples, but some of these examples that I mentioned here are sufficient. Okay, now, why have we seen a rise of activism? So, in the recent times, activism has increased because of these reasons. Point number one. See, you have to always understand this very important point, that there is an asymmetry of power in the country. In the very first class, we had discussed about a case called Ram Javaya Kapoor case, where the court had said very clearly that everything in this country is being done by the executive, the government. Government is extremely powerful in a parliamentary setup, extremely powerful. Who will keep a check on the government? The idea that executive is extremely powerful. And somebody has to keep a check on the executive. So sometimes to remove that undue discretion, it is required. Then sometimes, due to also the indifferent approach of the other organs meaning the legislature and the executive, right? So because of sometimes undue or indifferent approach. So this reminds me of this scene from this movie Nayak, right? Or the other original version made by Shankar. If you have seen the movie and you remember the scene where this actor Anil Kapoor or Arjun, he in the very beginning starts shooting the scene where the bus drivers and the conductors and the college students are fighting, and the entire city is burning, and the commissioner of the city has called the chief minister that, sir, what should we do? And the CM, what does he say? The CM says, don't do anything. Let people cry. They'll fight, they'll get tired, they'll go back home. Why? Because The bus conductor lobby is my vote bank. The students are supporting my party. They are from my caste group. This one is from my caste group. Don't involve anybody and don't get involved also. Let it be. Sometimes governments don't take action deliberately because whatever action you take may have some repercussion that will come to bite you. For example, the Sabrimala issue. Very simple. Now, in the case of Sabrimala, there are two ideas about it. Number one, don't allow entry of women because of a religious practice. Number two, allow entry of women because of equality. Now, there are people in the public who are supporters of either of the two point of view, the points of view. Definitely. Now, if I pass an order or make a law, come on, no entry of women, I lose out on all the progressive and the liberal voter, right? If I pass an order, allow entry of women, come on, then I lose out on all the voters who are believers in the faith and religion, who want that respect and the fine line being drawn between religion and the state. I lose out on them. So I'll remain silent. Simple. That's again a point where sometimes the courts have to interfere. Then, increasing awareness amongst masses. With the increase in the literacy levels, awareness levels, people are becoming more and more aware about their rights, so they are filing more cases. As simple as that. Now, globalization. World over, now this entire planet is a global village. We know what is happening in other countries, etc. And it's very clear. It is very, very clear that there are some very interesting developments along the human rights or in the field of human rights in various countries, right? And we should always be willing to learn. And also in a lot of other countries, we have seen way before us, they gave a lot of rights which now we are slowly incorporating, be it the rights for transgenders, be it the right of consent, etc. All these things. We are always learning about how the other countries treat people with an enhanced set of fundamental rights, right? So we also keep on improving the quality of rights being given to the people, constantly improvising and giving more and more rights to people, right? So some other countries knew that right to privacy is very important, but we gave that only in 2017 as a part of fundamental rights. Okay. Or something as recent as the idea of consent, the idea of marital rape is now being discussed in our country, that this is also a reality in the country, in the society, that these things happen, right? So these progressive steps are being taken and are under discussion, and sometimes courts instruct also decriminalizing homosexuality, right? In Western countries, it has been allowed since ages. So we constantly keep on progressing. Now, active media plays a very important role in making people aware, exposing the shortcomings of the government, the failure of the government, bringing that to light, taking that matter to the court, forcing the court to take a step, take a stand. Very important. And lastly, advent, the coming in of PIL. What is PIL? PIL stands for Public Interest Litigation. So what's this concept of PIL? Just to tell you in a very loosely, PIL is a judicial procedural innovation which relaxes the concept of locus standi. Now, what's the meaning of locus standi? It basically means, let us say your house has been robbed. Now, you will go to the police to file complaint, etc. So only an affected person can approach the court. If your fundamental right is getting violated, you go to court. What is my concern? Why should I be allowed to go to court because your right is violated? If somebody, let's say you belong to Maharashtra and somebody from Nagaland, his house is robbed, will you go and file a complaint to police that I read a newspaper that person's house is robbed? Come on, file a complaint. Of course not. Locus standi. What is your locus standi there? What is your personal interest there? What is your association there? Nothing. Then get lost. But it was realized that it may not always be possible for people whose rights have been taken away to approach the court. Maybe because of knowledge, because of resources, maybe they are too afraid. Think of an example where there's a case of, say, domestic violence, right? Now, when it comes to domestic violence, what happens is, let's say you are going to your house and your neighbor next door. Every day you're hearing some cries that the spouse beats the other spouse. It could be the husband beating the wife or vice versa. Anything can happen, right? Why to blame one gender only? Now, let's assume the husband beats the wife. Let's assume an example. Now, in this case, the wife may never be able to approach the police. She may be too afraid. Possible. She may not know any better what to do. The same can go for the husband also. So sometimes it may not be possible for people to approach the court. They may not have resources. Then how will their rights be upheld? So the idea being that the court will relax the procedural restrictions of locus standi. The court will not ask, you are not the affected party. Why have you come? I have come because the affected party could not come to court. He has no knowledge. So in PIL, what happens is, this locus standi is relaxed and any person or group can approach the court in larger public interest. This is called locus standi. Are you clear? So the idea being that the courts have been able to relax the procedures, right? Party is not affected, may bring a dispute. Judge can initiate the proceedings on their own, right? Then sometimes the Supreme Court and High Courts also allow you to present evidences. So normally evidences are never presented in the Supreme Court and High Court. It's only in the trial court. So what you see in the movie is a drama happening. Where is the blood-soaked weapon? Were you able to see the person at night? There was so much of darkness. How could you see the person at night? All these cross questionings, the trial, establishing facts and all, it takes place at the trial court level. This drama does not take place in Supreme Court and High Courts. But sometimes in the case of PILs, it is allowed. Right? So that is what is the advantage of a PIL, that the courts can interfere and can take up a case even if the affected party is not able to approach. A very good example, which is also very popularly called the mother of all PILs, is the Husainara Khatun case of 1980. This case relates to prisoners languishing in jail, under trials in jail for years and years, Finally, the matter went to court. The court instructed all the jails and the executives there that send out, prepare a list of all those people who are waiting for their date in the court and make arrangements so that they get their dates as quickly as possible. Because in this case, the court came to realize that there were people, 40,000 people across the country, later on, not in this case, but later on, that there were 40,000 people across the country who are waiting for a court date, accused only, in jail. Now, of course, now the number has crossed 3 lakhs. That's a different story, but that was the case there. And it became very popular. And this had opened the gates for further such cases being accepted by the courts. And if you have to attribute this to two judges, I would attribute it to Justice P.N. Bhagwati and Justice V.R. Krishna Iyer. They should be called the pioneers of PILs. The ones who relaxed the court procedure and allowed the parties to file cases. I have given various examples of PILs in various areas, be it the prison reform, be it for women, be it for child rights, be it for environment, be it for governance. So you can mug up these points and you can write in your answers as examples of PILs, right? Like a few years back, a question was asked on environmental PILs. This time in the exam, a question was asked on women's rights. You can mention how the courts have also given various judgments and have tried to uphold women's rights. So, say for prison reforms, humanizing the prison administration, improving the quality of prisons in the country, under trials in jail, the case I just mentioned, Husainara Khatun case of 1980, right to speedy trial, right? Kadra Pahadia case. So all these are cases where the court has given instruction to the executive. Humane treatment of detainees. When the police detains somebody, please don't ill treat them. Don't beat them. DK Basu case, 1997. Limiting solitary confinement. We had seen this earlier. Shatrughan Chauhan case of 2014. If you remember, do you remember Shatrughan Chauhan case by any chance? What topic? Clemency. Somebody had mailed me a couple of weeks ago that, sir, Shatrughan Chauhan case is of 1914. How? There is no Supreme Court in 1914. Why would you mail this to me? Despite very clearly mentioned in the slides, it's of 2014. Okay. Then avoiding excessive handcuffing. So handcuffing is actually not something that the police should do. See, a movie sends such a wrong message. In the movies, they always show whenever the police enters, handcuff, they bring the handcuff, right? But handcuffing is not something that is a norm. It's an exception. You have to take the written permission from the magistrate, the judicial magistrate, before handcuffing somebody, or you have to explain and write an application why you had to handcuff the person, whether he was trying to be aggressive, etc. So that's the case. Now, in the case for women, sexual harassment at workplace. The very famous case, the Vishakha Guidelines of 1997, which was a direct result of a Bhavri Devi rape case in the country. So a lady who was employed by the state government in Rajasthan, she was allegedly raped by some people in the village just because she was performing her duty of trying to curb child marriages. And she belonged to a lower caste. She was raped by some people of some other caste. And you'll be surprised that they are yet to be punished. This is a case of early 1990s. So she is waiting for her own justice. The perpetrators or the alleged perpetrators were never punished. Right? So that's the whole scenario. But anyway, because of this case, what exactly happened was that a very important element came to light, that we are all talking about the progressive nature of jobs, that now it should be more gender neutral. But if women are not safe at their workplace, where and how will more women come out and work, right? So guidelines were given called Vishakha guidelines, and this was to ensure that every organization, public, private, semi-public, every organization has to, that there are some rules and regulations in place to prevent harassment of women at their workplace. In fact, till 2013, Vishakha guidelines were the only guidelines in the country. It was only we have to know the sleeping or the conscience of our ministers and the conscience of our politicians only awakens when a big case happens. So it was a Bhavri Devi case which forced the court into taking an action, and then the Nirbhaya case in 2012, which forced the parliament to make a law. Finally, in 2013, the law was made by the parliament. That law is called the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. That's a silly and sad state of affairs of our politicians, that it takes some excruciating damage to an individual to wake them from their sleep and slumber. But now we have a law in our country, but still this is what is, that law is still called Visha guidelines. That's how popular these guidelines are. Or the nutritional and feeding norms for women. So for lactating women, breastfeeding women, it's very important for them to have a balanced food, etc. So again, instruction from the courts to ensure that they get some special care. Then inheritance of property rights for women, that has come from court judgments, right? The equality in property rights. Then one very weird situation in our country, not in our country only, it's there as a problem everywhere. One-sided lovers. And the movies have taught all this nonsense, that it's okay, right, to chase somebody, to harass somebody, right? It's okay. It's okay to change your name and get a false identity and chase an individual. And these are cult movies. So a very similar cult movie, I think, is starring the legendary actor Madhavan, both in Hindi. I think the Tamil version, I don't remember the name of the Tamil version, but in Hindi it is Rehna Hai Tere Dil Mein. What was that? It was a stalker movie only, right? Frankly, I mean, with all due respect to the fun and frolic. So, and then what happens? People, Minnale in Tamil, yes, absolutely correct. I think Jyotika was the actress, if I'm not wrong, or maybe Trisha, I don't know. So the point here is that these people, see, in the movie Kabir Singh, they are showing that the person is still clearing college, etc., doing great and drinking every day, still maintaining a fit physique, looking amazingly nice on screen. In reality, that will not be the case if you drink like that, right? And conducting operations and all. People watching Kabir Singh will go out and start drinking immediately. Movies have impact, right? Oh, Rima Sen in Minnale. Okay. My bad. So the point is, that because of these things, people take their no, I should not disrespect anybody's feelings and all, but if you are going to do all this, then you don't have any feelings. Then people will have this kind of tagline: if you can't be mine, you can't be anybody else's. Have you heard of this statement made by some enthusiastic one-sided lovers? And then what do? You throw acid on somebody's face, right? And you destroy this person's entire life. Recently, there's a case in some northern part of the country where this guy actually burnt a girl alive, burnt her alive, and was smiling, standing near her burning. And the worst part is, in the media and on social media, people were debating about whether he was a Muslim or a Hindu. I mean, that is a real debate, right? Whether he's a Hindu or Muslim. Imagine the priorities of our country, sadly. So, in 2006 only, the Supreme Court had given instruction in the Lakshmi case that sale of acid has to be regulated. You have to regulate it. So without ID proof, concentrated acid cannot be purchased. Now you may say, but sir, still acid attacks are happening. How are people able to purchase? Supreme Court can only give a judgment. Whether it is being implemented properly or not is better left for the government to decide. Now what can we do? It's just like I can tell you to revise. I can't revise on your behalf, right? The idea is that you can take a horse to the pond, you can't make it drink. Simple. Then separate police lockups for women. We have seen various situations where the police would try to keep the women detainees in the same lockup as the male detainees. So Supreme Court came down heavily on the executive that this should not happen. Sheila Barse case, it was an 83 case, not 87 case, where this judgment came. So you can use all these in your answers. Then child rights. These are landmark cases. These are not some generic kind of cases happening. Yes, Chapak movie is based on that story only, of this lady, what she had to undergo, played by, I think, Deepika Padukone. The movie did not do well because of Deepika Padukone's, I think, participation in the Shaheen Bagh protests, if I'm not wrong. Okay, so now child rights. As far as child rights are concerned, establishing juvenile courts for under 18 with trained officers. Very, very important that trained officers are there to look into the what? Cases involving kids under 18. They need to be treated with a lot of sensitivity. Okay. Then preventing child labor. So one of the country's legends who also won the Nobel Prize, that is not the reason for him being an amazing person, but the reason is that his organization, Bachpan Bachao Andolan, has saved lakhs of people, lakhs of kids' lives, right, by saving them from child labor. Kailash Satyarthi, right? And I hope you all know who is Kailash Satyarthi. You should know, right? He runs this NGO called Bachpan Bachao Andolan. Of course, we would know him because of he getting the Nobel Prize, sharing it with Malala Yousafzai. But anyway, so kids not being allowed to work in circuses through Bachpan Bachao Andolan case only. They filed a case. Thankfully now we don't have circuses only. at least a lot of big platforms have simply boycotted having circus shows because it's nothing but inhuman, or rather ill treatment of animals, inhuman treatment of people there. It's no entertainment at the cost of ill treatment of other living beings. So it's not there now. So at least big platforms don't support these circuses. You won't have any shows running where you can purchase tickets online for these. Maybe it's still happening in some part of the country. It should come down. Then kids not being employed in match factories. MC Mehta, a very famous social activist. In this case of MC Mehta of 1996, again Supreme Court gave the judgment wherein Supreme Court said that no kid to be working in match factories or in carpet factories. There is a Bandhua Mukti Morcha case of 1997. I am giving you landmark judgments, right? So Bandhua Mukti Morcha case, where Supreme Court said kids will not be, when I say kids, I mean under 14, okay, in all cases. Otherwise, under 18, but normally under 14. So if I am referring to 14 to 18, I'll use the term adolescents, okay? Now, Bandha Mukti Morcha, or this ragging, preventing ragging. The prevention of ragging, the guidelines to all the schools and colleges has come from Supreme Court. The Vishwa Jagriti Mission case of 2001. Otherwise, these colleges and schools will not keep any check on ragging. I mean, the amount of trauma a kid will undergo for his entire life because of ragging. It's very important to keep a check. Yes, we understand there should be a healthy relationship, fun and frolic is okay, but not at the cost of targeting somebody. That is what is the collective conscience of the people, that they form groups and they start targeting an individual. And what he or she undergoes is they are scarred for life, right? So some of us may have an amazing school time memory, not them, who have been scarred for life. So it's very important. I think there's a movie made on this concept only. I think Table Number 21, starring Rajiv Khandelwal, Paresh Rawal and all. So, Sardarni, what is ragging? Oh, that's a good thing actually. It's amazing that you don't know what is ragging. This means that maybe in your school or college, it is not happening. When seniors come and disturb you, harass you, that would be called ragging. Simple. Then in the area of environment, so in the there are too many movies on this in South. Really? Name some movies, Bhagya. Let's see. What movies do they have? Okay. Healthy environment. Supreme Court has said that Article 21 now talks about Article 21 also includes right to healthy environment. It's not just right to life, but right to healthy environment, right? So this is Article 21, and this was the Dehradun quarrying case of 1988, where Supreme Court said that right to healthy environment is a part of right to life. Okay. Then polluter pays principle. Yes, these two will be studying in your environment classes on what is a concept. When you pollute the environment, you have to pay for it. And absolute liability principle, more in environment classes on these things. Firecracker ban, right? The Arjun Gupta case, where the Supreme Court gave instruction on banning firecrackers. Okay. Then BS4, Bharat stage. So again, this will be something you will be covering in your environment classes. Bharat stage. What are these things? Bharat stage 4, stage 6, these are vehicular emission norms. Your vehicles, to what limit can they emit SOx and NOx, the nitrogen and sulfur oxide gases, right? So implementation of it has been ordered by the Supreme Court in the MC Mehta case 2018. Clear? So you can see that Supreme Court interferes and gives these orders on various topics. Then in the case of governance, there was this case of PUCL only. It was only after this case. PUCL stands for, it's an NGO called People's Union for Civil Liberties. In the PUCL case, it was in this particular case that the Supreme Court said that every person who has to contest elections must give their criminal antecedent, criminal history. How many cases are pending against them? How many cases have been filed against them? All these things have to be mentioned, right? So that's there. Beyond that, appointing SITs. What is SIT? Any idea? What is SIT? Nobody? So SIT stands for the Special Investigation Teams. SIT. Then appointment of Barkar, Google search for it now. PUCL stands for People's Union for Civil Liberties. Okay. Now, appointment of CBI director, their tenure, etc., or the ECI members' appointment, etc., all these have come through Supreme Court judgment. The Vineet Narayan case, you'll be studying more about this in your governance classes of 1997. Or the case this year only, Anup Barnwal case, where the Supreme Court said that the appointment of ECI members will be done by a committee, not by the government on its own. Same goes for director of CBI. So these are numerous PILs filed in this regard with respect to what? With respect to the or in the area of governance, right? Okay. So my advice would be mug up at least some examples from all these topics. It's very, very likely that a question can come. It has come. It will come again. Mug up some points. You can simply write them in as an example in your answer, and also some latest recent examples. These examples would suffice for at least next 2 to 3 years. Clear? Okay. Now, what is the positive implication of these things? Positive implications. Vaibhav, no prelims question would come from this topic largely. It's a more of a mains oriented topic. Needs proper elaboration. So that's how it is. See, first things first, it prevents undue discretion in administrative decisions. Government will always work for vote bank politics. They may take any random decision without even going into details of what is issue, concern, etc. A very good example is Maratha reservation. Right. So this was cancelled by Supreme Court because Supreme Court held that Marathas did not constitute the backward classes in Maharashtra and did not appreciate also the government's, I think it was a Gaikwad committee report. They did not appreciate the report's findings also, which it did not find to be logical enough to provide for reservation, right? Same goes for OBC reservation for JATs also, right? So discretion, that undue random discretion that the government has, that is kept in check, because the government knows there's somebody at the top who will cancel my orders if I do all this nonsense of vote bank politics. Then it has also promoted transparency in governance. Transparency in governance has become uh, very important as an element, and this has come through various court judgments. Simple example being declaring the criminal antecedents. As I said, the criminal antecedent, criminal history, education qualification. So whether it is the education qualification or declaring the criminal history for all the candidates contesting elections. Okay, then as I gave the example of Bharat stage 4 norms, 6 norms, right? So the idea is, I initially also told you about how the government sometimes says, don't do anything, let people cry, let people suffer, they'll go back home. Why? Vote bank politics. Sometimes governments deliberately do not take any action. Governments know very well what should be done, but they will not take any action. Why? Vote bank. Why should I antagonize some group? They'll keep quiet. Simple. Automobile sector needed some revamp, because what is going to happen is that when it comes to these emission, so for those who have no idea what is all this, don't worry, you'll be studying in your environment classes. It is not for the polity class to discuss the Bharat Stage 6 norms of sulfur oxide emission and nitrogen oxide emissions. Environment class. I'm just giving an example. Now, when it comes to the Bharat Stage 4 and 6 norms, the idea being that all these automobile companies, if you have to change the emission by your vehicle, it requires what? It requires changing the engine as well, which may lead, which may require lot of input costs being increased, because you have to change the entire setup. Now, the governments did not want to give orders to these automobile sectors to make these modifications. Maybe it was because these big companies fund the governments in elections, or maybe it's because the country did not want to, or the government did not want to slow down in the growth of the sector. They kept quiet. Finally, court said, come on, by April 2020, all vehicles have to meet a set standard of emission. So now the government said, sorry, what can we do? The court is saying we have to implement it. They keep quiet, right? So this is there. Or the decriminalization, or even Sabrimala. The Sabrimala case, where the Sabrimala case, where the government has remained quiet, has not made a single statement. Why not? Why to antagonize any group? Keep quiet. Let the courts decide. Then, it has also helped in striking the balance between inherent values of the constitution and the changing times. A very good example is the widening scope of Article 21. If you look at Article 21, so for those who do not know what is this Article 21, Article 21 is a part of fundamental rights, which is called right to life and personal liberty. Meaning, your life and liberty will never be taken away without following a procedure. Does that mean that you have just live survive somehow? Of course not. Right to life means way more than just living. Right to live with dignity, right against public hanging, right to privacy, right to reputation, right to speedy trial, right to timely medical treatment, right to education, right to or right against solitary confinement. All these are now a part of Article 21. How? Supreme Court over the years has kept on giving judgments to widen the scope. Everything is now covered in right to life. So this is because the courts keep on interfering, pushing the boundaries of these rights. To give you a simple example, uh, in the MTP Act, the Medical Termination of Pregnancy Act. So in our country, or anywhere for that matter, abortions in most places is not something legal or something to be done legally. You have to seek medical help, and that is the right way of doing things. Now, in the MTP Act, uh, it talks about married women getting abortions. Now, the court held that with changing times and circumstances in society, it is not always the case that a married woman will only get pregnant, right? So, in a recent judgment, the court held that in the MTP Act, married women will also include unmarried women, widening the definition of that word. We always have to keep in touch with the changing circumstances and evolve accordingly. That's why we say that the evolution process is never complete. We always keep on growing. We keep on improving. 50 years back, live-in relationships, it was unthinkable. Now it's pretty common, right? 50 years back, inter-caste marriages, interreligious marriages, unthinkable. Now it's okay. We always keep on improving ourselves. Some years back, animal sacrifice was okay. Now it's looked down upon, if not strictly banned. So we can never be liberal enough. We can never be woke enough, right? Every coming generation is going to find the older generation too conservative. That's how it is. We find our parents conservative. The kids in the school days, they find us conservative. Simple. So that's there. Then it has also helped checking government inaction in areas of environment, in areas of police reforms, corruption, electoral reforms, all these areas. When governments will not take a step, the courts will interfere. And finally, it has also played a complementary role with respect to parliament. As I said, the example of Vishakha guidelines, or the decriminalization of homosexuality. Right. So reading down of section 377 of IPC. So there used to be a section, there still is, section 377 under IPC, which says that as far as the law is concerned, it is a criminal offense to engage in any kind of unnatural sexual activity which involves kids, animals, even adults, consenting adults. So of course, that's a very strange thing, These laws have largely a religious kind of origin. And it's very strange, right? Have you observed that all these religions are so peculiar and so focused on what people do in their private space? Amidst so many things that they could worry about, they worry excessively too much on your private space. Surprisingly. And initially, in 2013, Supreme Court actually cancelled Delhi High Court's judgment and said that we will not interfere, let the parliament decide, right? But for 4 years, parliament took no step. Why would the parliament make a law to decriminalize homosexuality? A lot of people in the society may not appreciate it, right? That's the hypocrisy in the society. When in India, we will not teach kids about safe sex, it is hypocrisy. We are the country with the largest population. So this is a case. But anyway, in 2017, in the Navtej Singh Johar case, finally Supreme Court said, by we Parliament, we gave you time, you please decriminalize it, or we are doing it. And the Supreme Court gave a judgment. Now section 377 only contains kids and animals, that is pedophilia and bestiality. Consenting adults, it is no longer a criminal offense. So all these things have come through what? Come through Supreme Court orders. Nice, amazing things about activism. If it's so amazing, then what's the problem? Right? I hope now you've understood that activism is required. Yes or no? Lakshya, ignore it. That's of no relevance. It was just a metaphor. Ignore it. Okay, fair enough, fair enough. I fully agree with your enthusiasm that yes, it is very important. Let me just focus on or bring to your attention some other important elements. So recently, all those people, now I know some of you are believers in religion or spirituality or God, it's totally your choice. But I hope you'll all agree on this one point, that there should be a minimum age for marriage. Yes or no? I mean, kids getting married just because my religion says so, now that may not be correct, right? Everybody, even the ones who believe in religion. Recently, Ashwini Kumar Upadhyay, one petitioner, he had gone to court to file a case that there should be uniform marriage age. Irrespective of your personal law, the age to marry should be uniform. And it is so silly that for other cases, a kid under 18 has no right to give consent. But certainly, if my personal law allows for it, I can marry a kid under 18. Right? So, Supreme Court dismissed it, saying, no, Parliament will decide. So, uniform marriage age in 2023 only. Okay. Recently, one more case was filed. This was the Bombay Lawyers Association case. In this case, these petitioners were seeking the court to give instruction that there should be some cool-off period. So immediately when you retire as a post of a judge, so when you retire from the Supreme Court, of course, you're not allowed to practice anywhere in the country. That's a very good point. Great. But when you retire from the post of judge, can you become a governor somewhere? Or can you become an MP in the Rajya Sabha? Yes, you can. Yes or no? You can. We have examples. Now tell me something. S. Abdul Nazir, he gave a judgment in the Ram Janmabhoomi case. He gave a judgment in the demonetization case. And in both cases, gave a judgment in favor of the ruling party, which the ruling party wanted. On his retirement, he was made the governor of Andhra Pradesh. Now, we are not questioning S. Abdul Nazir's judgments. Maybe he's a great judge. But again, the same old story. Justice should be seen to have been done. If you are giving judgments in the favor of the ruling party, and then immediately you are made or or given a very important post, then how will people feel, or what will go in the minds of people, that maybe there is some kind of quid pro quo. You scratch my back, I scratch yours, right? You help me out, I'll help you out. This is a concern, right? So the association went to the court saying that we are not questioning S. Abdul Nazir's appointment, but what we are saying is that there should be some kind of cool-off period, that after you have retired as a judge for say 5 years or 10 years, you should not be given any kind of appointment from the government, whether it's a post of governor, the post of MP in the Rajya Sabha, etc. Supreme Court said, sorry, we can't interfere in all this. Of course, it was to keep a check on their power in future. Cool off period for retired judges. To take posts post retirement. See, or mind you, there are a lot of cases which are still unheard. For example, CAA, the Citizenship Amendment Act, or the Shaheen Bagh protests, EWS reservation, the discussion on Article 370, or Bhima Koregaon. Various such examples where the cases were pending for 2, 3, 4 years. EWS reservation was only heard in 2022. Article 370 only now. Delay in taking up important cases, right? Further, just to draw a parallel here, on one hand, the courts don't have time to discuss CAA or Article 370 or the Bhima Koregaon. Bhima Koregaon was this issue between the Dalits and the local people in Koregaon, because this in your history class you'll be studying about the Third Anglo-Maratha War. Under that Third Anglo-Maratha War, there is this Battle of Koregaon, where the British army defeated the Peshwa, Bajirao II. Now, of course, the British army, what is British army? British army largely comprised of the Dalits there. So Dalits see this as their own victory against the others. And in 1927, Ambedkar had gone to this place. So Victory Pillar is there. So a lot of these Dalits went there to celebrate, commemorate the victory. And the localites did not like it. Protests happened, fight and all. Cases were registered. Some people jailed. Yes, of course, people like Stan Swami was jailed. Surendra Gadling was jailed. Sudha Bhardwaj, Kabir Kala Manch. The point is that, see, I'm in no support, let me be very clear, of people like Stan Swami. Their ideology only seems to create a divide in the country. But that's not the point. Whether you appreciate the communists in the country or not, you have to understand that today the government might suppress their voice and you can sit and laugh, but tomorrow it'll be us. So frankly, these pseudo left-wing liberals will never stand up for you, but it's okay. We have to stand up for the rights of everybody, whether we politically align our views with you or not. That is not our concern here. Stan Swami, 80-plus-year-old person, died in prison. Why? Threat? What threat is he causing now? Person is suffering from so many diseases. The court had no time to look into his petition. Why? Because the court is very busy in discussing Arnab Goswami's plea. Or Kangana Ranaut are able to understand what I'm saying. Sometimes you will find that the court takes no action on very important matters. Sometimes there is complete inaction or delay on the part of court in important cases. And sometimes there is over enthusiasm in taking up some cases involving high profile people. And not just this, beyond this, you will find that very good example, ban on sale of liquor on national highways, right? The point is that ban on the sale of liquor on national highways. Where is the data? Supreme Court said within 500 meters of range of the highways, liquor will not be sold. Why? Because Supreme Court believed that people are drinking and driving and it causes death. Where is the data? There is no data. In fact, around 65 to 70% deaths in the country happen due to overspeeding, not drunken driving. And it can largely be attributed to poor condition of roads. This is government's data, 2020 data, NCRB data, 1.33 lakh people died in the year 2020. Normally, it's around 1.5 lakh deaths that happens every year on the road due to road accidents. 1.5 lakh people die every year. In 2020, it was a pandemic time, so lesser people, 1.33 lakh people. 60% can be attributed to what? To overspeeding and poor condition of roads. The point is that there is no proof anywhere that drunken driving causes maximum accidents. So, unnecessary interference in the executive domain, number one. Number two, firecracker ban. Initially, when this ban was given, what happened? No study was conducted. Randomly a ban. See, in the country, there's a problem. There are certain sections you can't criticize because what will people think? It's like going below the belt kind of thing. So that's a very standard provision in comedy also. You can never make fun of people who are deprived sections. In our country, farmers in general are suffering. This does not make them right always. So stubble burning is also a reason for high levels of pollution in Delhi and neighboring areas. So that also needs to be checked. Okay. So when the court gave a ban, there was no study conducted on what is the contribution of firecrackers, what's the contribution of stubble burning, and firecracker ban on one festival. That is wrong, but on the 1st of January, it's okay. Then there is no harm. So without conducting studies and all, if you give direct bans, that is not appreciated. Later on, study was conducted and then ban was given, etc. That's secondary. Then I gave the example in the previous class also. Mandatory playing of national anthem in theaters. Now, please tell me, especially those who believe in religion and stuff, that whatever religious verses you read, there is a decorum, place, time, etc. to recite those verses, right? National anthem is not a song. It's not sung, okay? It is always performed. Demonstration of the anthem. And how would performing a national anthem in the theater elevate its status? Imagine you play the national anthem. After the anthem is over, some Imran Hashmi movie starts playing, right? Or some movie with full of crassy dialogues and violence and sex scenes, etc. How is it improving the respect and decorum for the anthem? You're just making fun of the anthem also by doing all this. People have come there for entertainment, let it be. And if at all you want the anthem, let the government decide where to play, how to stand, not to stand, etc. So courts trying to act like who is the real nationalist? Oh, government, no, we are better. This is our judgment. So are you on this bandwagon of populism now, that to gain popularity you'll give any kind of judgment? Problem. Look at this collegium. What is this collegium case? The collegium system, where you have completely freed yourself from any external control, denying executive any role in the appointment of judges. No country has this. What is this obsession? Right? Or sometimes courts make very weird kind of remarks. See, if we in our drawing and living room discussion make a remark, it is okay. I mean, no problem. Nobody knows. But judges, when they make remarks full of exasperation, people may misinterpret those remarks. Couple of years back, in Tamil Nadu, in the Tamil Nadu elections, one candidate, M.R. Vijay Bhaska, he filed a case saying that in Karur constituency, that a lot of people did not turn up to vote and all. Election Commission did not organize the booths properly, and Election Commission is responsible because of pandemic. There's a problem. Madras High Court said that Election Commission, the officials should be booked for murder charges for not maintaining safe distancing norms in the polling booth and during elections. Booked for murder charges. And statement out of anger. Now, when this statement was made, Election Commission of India, so Madras High Court, so Election Commission of India issued a public letter, said it is not our duty to maintain safe distancing norms in the entire state. It is the duty of the State Disaster Management Authority. It's your duty. It's your responsibility. Now, SDMA came out. SDMA said, no, while elections are going on, it's the duty of ECI to take care of all such things. Now, they both are fighting. Madras High Court is sitting and enjoying. Let them fight. Recently, there's a case involving this woman called Nupur Sharma, when she made a statement on one news channel. Now, see, we won't get into the statement's details and stuff. The point is, when she made a statement, possibly your religious belief can be hurt. appropriate, go to court, file a case. No problem. Don't take law in your own hands. Because of that, there were cases of beheading in the country. Now, Nupur Sharma had gone to court. She had claimed that multiple cases are filed against me across the country. Courts, please bring all the cases to Delhi. It's the same case. In that particular case, the court, I think it was Justice Suryakant and J.B. Padiwal, if I'm not sure, if I'm not wrong, they gave a statement that the loose tongue of this lady has wreaked havoc in the country. What is that got to do with beheading of people? And when you make such loose remarks, people with their limited understanding, they will perceive it as, oh, see, the court has also said the lady is at fault, kill more people. You did not even make a single statement against those people, telling them that if you perpetrate these kind of activities, strict action will be taken against you. No. You are saying, oh, lady, come here, useless fellow. And if you are so serious about what you are saying, why are these statements not a part of your court judgment? No, they are not. These open court observations are prone to misinterpretation by people. So as a judge, you cannot show desperation, exasperation, right? You have to be very strict and very clear in the choice of words. So these are the problems in our judiciary. Now, this is an area which we will refer to as overreach. Sometimes you see overreach happening, sometimes inaction happening, sometimes no action being taken, sometimes over-enthusiasm. All these are examples. These are what are the issues. Because we don't know when the judiciary will interfere, when it will not interfere. If there is a high-profile case, date immediately. Otherwise, no date only. Otherwise, no judgment only. And otherwise, judgments, interferences. There should be a clarity. A sense of clarity that, okay, the court is there. It will ensure the rights of people are upheld. But you are eager to take up a hotshot case, but one Siddiqui Kappan is languishing in jail for 6 months, or was for 6 months, chained like an animal. Why? Because of his reporting in the case of Hathras. How is this fair? So these are some concerns, issues. But sir, as we know, such high-profile cases are dealt by more than one judge. Then even if he is biased, there are other judges too. Sir, what is the point? What is the point of the statement? Lakshya, so but think. So Lakshya again, don't make simple statements. Give me the context also. EWS reservation was given in 2019. Now in 2022, finally court took up the matter to verify whether it is constitutional or not. In the last 3 years, the law was already implemented. People were getting admitted to these institutions, organizations for jobs. Now, can you take that back? Not possible. It's like demonetization. It took you 8 years to discuss on demonetization. Now, even if you find demonetization wrong, let's say you find it wrong, what can you do? Can you cancel it? No. So if there's too much of delay, then the problem is that the courts can do nothing about it. Okay. Abhishek in reservation, not right now. Yes, Shargun, BCCI also. Divya will discuss that later on under rights. Yashi, file a petition. Simple. So now the issues. First things first, it of course is a clear-cut example of violation of separation of power. Of course, it violates the separation of power without doubt. Because now judiciary interferes in the domain of executive and legislature. Number one. Then think of a simple example. When you are or when your day-to-day action is scrutinized a lot, you may not be willing to perform the task properly. See, in the examination hall, when you're writing your answers, what if the invigilator comes and stands beside you and he looks into your paper and now you're writing your answer? You start feeling uncomfortable. And bhai, please go, let me write properly. You won't say that, but that's what your feeling is, right? Exact same thing. If people are going to be aware of this fact as officers, that whatever steps we take, judiciary will try to find some fault. We don't know what fault they'll find. So let's be quiet only. Let's not do anything. Excessive interference causes unnecessary delays in decision making. Then, government projects get stalled in certain cases. Why? A project starts, people go to court against the project, the courts will issue stay order, meaning, no, don't do anything now, wait, we'll decide. When? That we'll let you know. Now the project is stalled. It is stalled means stopped. It's waiting now. Why? Because the court has issued a stay order on the project and the court is not even deciding on the matter. Then it has led to inter-institutional conflicts. For example, I gave ECI versus SDMA example. Then possibility of personal bias creeping in. Personal bias, it does creep in your judgments. It is very natural. So I don't want to point out the names of any judges and all. Contempt of court. No, I mean, I don't want to point out names of judges. Why to point out any names? But some of our judges who are highly educated from various foreign colleges, because that is a tag that India is crazy about. Right? You learn something on your own. No value. College degree? Very good. Must be intelligent. And we know what is taught in the colleges. So the point is that in the West, now, the West has, see, if you have food in your stomach and a comfortable life and nothing to do, zero contribution, then these kind of unique thoughts come in your mind. How to become popular or how to, disturb or create chaos in society. Right? It's like the empty brains are devil's places and all. So in the Western countries, you'll find a new concept has come up with respect to gender fluidity. That now gender is something that you choose to decide on your own. It's fair if somebody a man wants to dress up like a woman or vice versa, it's your choice. Feel free. Who's stopping you? It's your personal life. Don't force others to follow your personal belief. Number one. Number two, now just because a man feels like he is a woman, should he be allowed or should he expect the society to treat him like a woman? Imagine a situation where, and this is happening, these men are now taking part in sports activities because they say, I feel like a woman, and winning all the medals and prizes. Right? Our judges are very eager to say that gender is a very fluid concept. Great, amazing. We should ask these judges, are you okay with one simple scenario? A male who claims that he is a female Are you okay with that male to be sharing a washroom with a 6-year-old girl child? And if things go wrong, then who is responsible? We have to understand that when you make all these statements and push society into thinking all these things, it's your personal bias. Maybe you have that great understanding, right? Larger public may not. That's a big problem. So we have to always question these people that when you give all these suggestions, what can be a possible ramification of it that don't think of? So yes, personal bias, a very, very important element. And that is very, very natural, which will happen. One more thing, problem of knowledge deficit. Knowledge deficit. Example, technical matters, religious matters. Judges give various kind of judgments on religious issues. Are these judges theologians? Do they have some degree in religion? No, but still they do. In our topic rights, fundamental rights, we'll discuss this, that the courts in our country decide what is essential to your religion, what is not. The courts decide now. They have no knowledge of religion, frankly. Some of them may not even be practicing a religion. Technical matters. Imagine a case goes to court, issue between two companies, say Qualcomm and MediaTek, Snapdragon processors. A case is filed. The court asks, what dragon? Chinese dragon? They have no idea. So you may not be an expert in everything. You're experts in law, but you may have limited knowledge in other matters. So there again, you have to restrict yourself. Also, polycentric issues. Polycentric meaning involving multiple people or multiple groups or multiple stakeholders. Example, if you are launching an, let's say, a factory or an industry, setting up an industry, so many multiple groups are involved. Government of India is there, government of state is there, the local bodies are involved, the people are involved, people who will get employment, people whose land may be taken away, right? Then we have the NGOs involved, and of course the MNC, which has launched the project. So many stakeholders are involved. Now, courts are not places where discussions happen in the terms of arriving at a common ground. Courts are adversarial places, meaning A versus B. A wins, B loses. B wins, A loses. That's what's a verdict. That's a judgment. There is no common ground. A common ground can only be achieved through discussions, mediation, conciliation. Courts don't allow for all these things. A is right, B is wrong. Done. Get lost. When you have so many stakeholders involved, it is very, very important to have deliberation, to have discussion. Courts are not places where discussions take place in this form to arrive at a common ground. Courts can give you a verdict. Who is right, who is wrong? In such cases, nobody is right and wrong. There are multiple points of view. That's a problem. And lastly, abuse of PIL. We have seen the nice side of PIL. That when the lawyers file PILs, just last topic, I will take a break. When the lawyers file PILs, amazing things happen, right? Great things happen. Judgments come, upholding rights of individuals. Not always. What is a PIL? Please initiate my legal career. Paisa income litigation. That is what PIL has become now, right? Popularity litigations. You just want to become famous. There are thousands of lawyers struggling. I want to become famous. The jolly LLB type lawyer. Of course, there are two types of lawyers. One this and one this. That's a reality. And lawyers want to keep on filing a case until they become popular. Some case which will bring them to popularity. Recently, there was this law student. Harsh Gupta was his name, a name not really important. Just last July, in July, he went to court filing a petition that all the provisions of all these laws that are there in the country, which are not gender neutral, like in the entire constitution, you'll always see the word he or maybe chairman. He says, replace all these. My lords, give a judgment, cancel all these laws, replace them with gender neutral terms. The court rightfully said, go and study. Don't waste time. Whether it is he or she, we know it's all gender neutral only. But since this kid has free time, goes and files the case. And the court warned him, better focus on studies. Don't waste your time. Or a very famous example of this Shrikant Malushte. This was the national anthem case where this fellow went to court saying that the Indian national anthem infringes on Pakistan's sovereignty. Punjab, Sindh, Gujarat, Maratha. Punjab, Gujarat, Maratha, India. Sindh is in Pakistan. Then the Home Ministry responded, etc., saying that this Punjab, Sindh, Gujarat, Maratha is with respect to the culture of these communities. And the petition was dismissed and he got a scolding. Or just recently, there was a punishment given. One lawyer wanted the court to give a judgment on caste system and phasing out reservation. Reservation removal. (2023). He had gone to court saying that, my lords, please give a judgment that we should reevaluate the caste system and we should cancel reservation in a few years. Again, court punished him, imposed penalties. What penalty? Per case, 25,000 rupees fine. Or there's a very interesting case of Rajiv Dahiya. There's an NGO called Suraj India Trust. This NGO filed 64 PILs in 5 years. Every year or every month, they'd go and file a case. Every month. All petitions dismissed immediately. After 5 years, finally, in 2018, the court said, sir, enough. Now we have to impose punishment. Punishment was imposed, 25 lakh rupees of fine. So nowadays, courts have become slightly more aggressive with respect to imposing punishments. But yes, abuse of PILs also happen. People have been misusing it. And that is why we say that PIL is not neither a pill nor a panacea for all wrongs. And there have been recent times, at least in the recent times, increasingly instances of abuse of PILs. We have to re-emphasize also the parameters within which the PILs can be filed and the parameters based on which the PILs are accepted by the courts. See, there are always two sides to a coin. There will be people who will try to and exploit PILs. Whether courts allow themselves to be misused or not, that is where the wisdom of the court lies. Right? So that is all as far as our issues are concerned. We are done with activism. Let's take a break. After the break, we will come back and discuss on what? I'll just give you some conclusion on activism, and we'll then move on to tribunals. Break, please. Come back at 7:15. H when up. Being supporters are can be wrong also. So that kind of on a who are entitled to receive free legal aid. Free legal aid. Mention that. Assess the role of NALSA in rendering free legal aid in India. Mention their functions. The eligibility, function plus contribution plus examples. Right? Direct question from the slides, of course, with all latest examples. Very simple. Are we clear? Kamlesh, you can mention that point. But the limitation is 150 words. Don't overdo it. Okay? I hope this question will be answered by everybody. Please write, and guys, please write your answer and send to target IES at Red Byju's. Clear? And please write answers in a proper format. Don't make a joke out of it. Writing answers in lines in your diary. I mean, how difficult is it to get an A4 sheet paper and get margins on both the sides? Is it that difficult? You can get these kind of things online on Amazon, Flipkart, etc. UPSC answer booklet. Okay. So please write answers in this format only. I had mentioned all these things very clearly in the case of our answer writing discussion. Jatal, the best thing would be to write about the purpose of NALSA only. As an introduction, the purpose of NALSA. Okay. One more question came in 2023. Again, a very straightforward question. Constitutionally guaranteed judicial independence is a prerequisite of democracy. Judicial independence, that too constitutionally guaranteed. Now, I don't want to boast about it, but have we not seen a slide on judicial independence? Yes or no? Including a separate slide on those provisions which are there in the constitution to ensure independence. Right? What can I say? And when I say please mug up the slides properly, they'll be of help. You still claim, no, sir, that book, this book. So sometimes the most basic thing is what is a requirement which you don't fulfill. Right? So see, understand, I also respect this fact that some of you want to get more and more knowledge. It's an amazing thing. But you are here for a purpose. And the purpose is to clear UPSC. Collecting knowledge your entire life is there. In these 2-3 years, please focus on preparing for UPSC only. Okay? Now, constitutionally guaranteed independence is a prerequisite of democracy. Democracy, majoritarian government, rule of majority, right? It is very, very important that we have an independent judiciary. Need of independent judiciary. So mention the needs. also mention that we have constitutional provisions to ensure that independence. And in the conclusion, please mention suggestions also to further ensure independence, especially of the lower judiciary, improving their infrastructure, right? And also ensuring that to further make them more independent, they should not be allowed debarred from future posts like the post of governor, the post of MP in the Rajya Sabha, any kind of nomination which the government gives. And if not completely debarred, there should be some cool off period that once you've retired, wait for 5 years before you can take up any kind of post. Some suggestions. Mind you, the word limit is 10 marks, 150 words only. Don't cross too much. See, and one more thing, when you're writing answers, the more important thing is to always write more points. Don't explain more, write more points. So less of explanation, writing in short bullet points only. So if you write in bullet points, you will save on words. So you can add more points. Never explain. Always try to replace articles with the entire statement. Okay? Kavya, PIL is a form of activism. PIL, yes, is a form of activism, of course. PIL is a reason for activism rather than a form of activism. Because Ananya, you are writing and then getting confused and cancelling and writing again. This shows confusion. If you scribble too much, sorry, then you write something. No. This scribbling shows confusion, lack of clarity. So we have to avoid this scribbling. Practice. Keep practicing, Ghulam Mustafa. Yes, Anum, it's okay. In most cases, it would be okay. Good presentation is a culmination of a nice introduction, a to the point body, and a very brief conclusion. That's called good presentation, including neatly presented with proper spacing between words and all. Satyapal, not really required. Nancy, this is something we cannot stop actually. So for that, I'll give you some points. This one. Yes, you can look at the PPTs and write answers, no problem. But start writing answers. It's okay. Look at PPTs, revise it 10 times and then write the answer. Now, don't copy from PPTs. Read the PPTs 5 times, 10 times, and then write the answer separately. Simple. Google search for it, no problem. But write the answer separately. Venu, read more editorials. Yes, madam, always. Satyendra, as many as you can remember. Simple. The more you can remember, the better it is. Now look at this question. Judicial legislation is antithetical, opposed to. What is antithetical? Opposed to the doctrine of separation of powers as envisaged in the Indian Constitution. Judicial legislation, meaning judiciary making laws, is opposed to the separation of power concept. Of course, legislature makes laws. Why should judiciary make a law? But it's okay. In this context, please justify the filing of large number of public interest petition, meaning PIL only. Praying for issuing guidelines to executive authorities. Very simple, straightforward question. In the intro, talk about judicial activism, but don't use activism, use the word legislation from here. Okay, once it's done, in the body, talk about how it violates separation of power. Then also mention why it is required, need for activism, and then give examples of PILs. Examples should be of two kinds. One should be those landmark cases, old cases, and the current few examples. And then in the conclusion, mention that they should not be overreach. So how would you say they should not be overreach? Very simple. See, as I said, that it is very, very important for our judiciary to understand that lines have to be drawn very clearly. What lines need to be drawn? The lines that we refer to, which need to be drawn, uh, are those wherein, just a sec, guys. Saying, when we say that we are going to talk about judiciary, the idea is very, very simple. And what's the idea? The idea is that if you have to impose restrictions on judiciary, what do you do? Number one, there should always be judicial restraint that the judiciary has to show on its own. Number two, judges have to be extremely cautious not to make random and vague remarks, because if you make vague remarks in open court, it is susceptible to misinterpretation by people. Number three, never ever, or rather refrain from criticizing the other organs a bit too much. Because if you over criticize the executive, the legislature, people start losing faith in these bodies, right? See, I'll give an example. If we here say police is corrupt, the bureaucracy is corrupt, it's okay. But if a bureaucrat comes out in the public and he says, I am suffering, all bureaucrats are corrupt, imagine the despair in the minds of people that look at this fellow, a bureaucrat saying that they're all corrupt. So people in the position of authority, if they show desperation and exasperation, people start worrying a lot. That should be avoided. And let me tell you, there should never be judicial governance. No judicial governance. Governance is a part of government. Let them do it. Please, no judicial governance at all, because always understand, misdirected enthusiasm is never consistent with impartiality. If you are over enthusiastic about something, you will never be impartial. You will always be biased. And that's the beauty of it. The strength of judiciary lies in understanding its limitations. That is where the strength of judiciary lies, right? So this is with respect to judicial activism and the conclusion. Clear? Yes, Soyab, no problem. See, Abhishek, and for others, some of you may say, sir, right now you're saying antithetical means opposed to, but in the exam, I'm hearing this word for the first time. See, one thing is that you can also make out the meaning of these words. And second is, you have to improve your vocabulary in general also. That's why I constantly keep on telling you, please read editorials on your own. But if at this point of time also you are relying on somebody's explanation, I'm not sure how your comprehension skills are developing. So it'll take some time, But reading these things on your own will also improve your vocabulary in general. Clear? Okay. Anuj. No, in this question, violations of separation of power, here in the conclusion you can mention that sometimes it can be an overreach. Couple of points on how it can be a problem and how to keep a check on that. That's it. Okay. So without mentioning those arguments which make activism become overreach, you can never write a conclusion. So opening statements in the conclusion have to be on overreach and then restraint. Okay, Mega. So conclusion is always suggestions. Best conclusion, suggestions. Sir, executive authority, sir. Government is the executive authority, sir. Megha, I just said, best conclusion is suggestions. Way forward. Clear? Okay. That's it. We are done. Let's move on to understanding tribunals now. Tribunals. So what are these tribunals? Tribunals are quasi-judicial body. Semi-judicial. I said quasi-judicial. Semi-judicial. Bodies which perform some tasks of judiciary, but not all the tasks, or not in the exact form and manner. Let me explain this to you firstly, and then I'll ask you a question, and you respond. So what is a quasi-judicial body? A body whose functions resemble that of court of law, meaning these bodies will also conduct hearings, just like courts do, hearing of case, make findings of facts, apply the laws, and also make conclusions. Eventually, these bodies will also resolve disputes. And there are various examples. These quasi-judicial bodies can be statutory in nature, like NHRC, the Human Rights Commission, the National Human Rights Commission. It can also be regulatory. SEBI, Securities Exchange Board of India. It can also be constitutional. And not just this, like say Finance Commission. Not just this. Sometimes you'll be surprised that Parliament also acts like a quasi-judicial body. Tell me, any example of a situation where the Parliament acts like a quasi-judicial body, meaning it will conduct hearing, making finding of facts, applying laws, resolving disputes, imposing punishment. Absolutely correct for most of you. The example is Article 61, impeachment process. Yes or no? When you are impeaching the President of India, are you not conducting a hearing? Are you not making findings of facts on how the President supposedly has violated the Constitution? Are you not applying the laws on him? Are you not drawing conclusion and then resolving the problem that, oh, he has done some wrong, removed from post? punishments. So all these bodies at various points of time can perform some judicial kind of functions. Tribunals are examples of such bodies only. Tribunals are one kind of quasi-judicial bodies. Are we clear on this? Everybody? Okay. Now see, now if you ask me, sir, are tribunals constitutional in nature? Yes. The word tribunals was originally mentioned in the constitution, but just the word, nothing else. So if you look at Article 136, we don't have that right now, but if you look at Article 136, if you remember, SLP, the special leave petition that the courts can take up any kind of case which has come through any court or any tribunal in the territory of India. This word tribunal is used in the constitution. But what is the meaning of tribunal, how to create a tribunal, etc., is not mentioned. Back in 1924, though not important information, but just to give you a brief, Justice Rankin committee was there. Justice Rankin, Rankin, not important. He said that, there are a lot of cases pending in the courts, and we can set up some bodies which can act as an alternative way to resolve disputes. Tribunals. Later on, in 1966, the recommendation came that we should have a tribunal for civil services. Then this 58th Law Commission report happened in 1974. Then this Justice J.C. Shah committee report also was there. So many committees kept on recommending that we should have tribunals in our country. Why, you may ask? Why do we need tribunals? Why do we need such kind of bodies which partially perform functions of a court? See, you have to firstly understand the advantage of a tribunal. Courts are places where you have controlled fact finding and controlled application of laws. You have to follow laws properly. CRPC, procedures are followed, lawyers have to be hired. I cannot go today and argue my case in court. That is not allowed only. Not allowed. I have to mandatorily hire a lawyer. If I cannot afford one, I'll get a lawyer. But I cannot fight my own case. When I am submitting evidences, I have to inform everybody that I am going to submit a new evidence. So what they show in movies, that people submit evidences. Entire court is shocked. A new witness has come in the court. From behind the court, he is walking, and people looking at the back, all stunned. This is good in movies only. In reality, any evidence you submit must be informed to the court prior to your submission. You can't surprise a court. You have to tell any document you submit, a copy has to be given to the other party. These procedures are followed. Indian Evidence Act. Right? It takes time. There's a delay because of all these things. Procedural aspects cause delay. Then courts may not have a lot of knowledge on technical matters. Right? Judges, experts in law, not in the technical matters. So what we have thought of is that we'll have authorities outside the court system which will interpret and apply laws. No problem. When the government's laws are challenged through formal cases, suits, case, or other established methods. Advantage: provide inexpensive justice, quick justice, fast, and to also unburden the judiciary. The already overburdened courts, some cases can be sent to these courts also, or so-called courts, or partially courts. And of course, increasing technicality of governance. For a simple matter, say the issues of environment. Now, the courts may not be experts in environmental matters. So, there's a separate body called NGT, National Green Tribunal, formed in 2010 only. This body looks into any and every kind of case dealing with various laws being violated. For example, if there is any violation of, say, laws on air pollution, for example, right? Or if there's any violation of the Forest Conservation Act, if there's any violation of the Water Prevention and Control of Pollution Act, if there's any violation of Environmental Protection Act, if there's any violation of the Biological Diversity Act, we have a body comprising of 10 to 20 experts who can give a more informed verdict than the judges, because they are experts in the field of environment conservation, etc. Right? Same goes for TDSAT. What is TDSAT? Telecom Disputes Settlement Appellate Tribunal, to settle disputes with respect to telecom services. So these are factors. And what are these quasi-judicial bodies or tribunals? Tribunals are an example of a quasi-judicial body. Very good. Of course, we know. Secondly, it is not a court of law, but enjoys some of the powers of a civil court. What is the power of a civil court? The power of civil court is to call any person from anywhere to become a witness. It's mandatory. If any body which has the power of a civil court calls you, you have to go and be a witness. If that body asks you to submit any document, whether you're a private body or a public body, you'll have to submit those documents. That's called the power of civil court. Clear? Calling people to be a witness and asking for submission of documents. Then they are generally free from the rules of Indian Evidence Act, Code of Civil Procedure. These things need not be followed by tribunals, not required at all. They just follow the principles of natural justice. No need to give information for evidence, no need to hire lawyer and all, nothing required. Right? What is followed? Natural justice. Simple. Are we clear? That is why we say it is not a court of law. Here, lot of procedures are not followed. More informal way of delivering justice. A more casual way of delivering justice. If you don't follow procedures very strictly, time is saved. Remember the voting in the parliament? Remember? Voting in the parliament. If we follow formal voting of pressing the button every time, it wastes 5-10 minutes. But informal voting, eyes, nose, task done, next task, saves time. Same thing here. The more procedures you follow, the more time is wasted. So, my question to you now is, let me draw a diagram and let me ask you what you would. The bigger circle and the smaller circle. The smaller circle in green. Should we call this a tribunal or should we call this a tribunal? I am writing this. This is a court. And the bigger circle is tribunals. So my statement is, all courts are tribunals, but all tribunals are not courts. Yes or no? Is the diagram correct? Or should I reverse it? Reverse it. If I Now, let me explain this. I am a person with the authority. Let's say I'm a body with this authority to solve disputes in the society. Okay. But then I have been told that you have to follow certain guidelines while solving disputes. If I was told you just solve disputes the way you feel like it, and later on I am told, no, not the way you feel like it, follow some procedure also. So my functions are being narrowed. If I was told that follow the principle of natural justice, solve a dispute, that's all we want from you, nothing else, it's okay. But suddenly I'm being told, no, solve the problems, but you have to follow rules and regulations. Now tell me, is this diagram correct or not? This diagram is actually correct. Okay. Tribunals are general bodies. Courts are special kind of tribunals which follow specific rules, regulations. Courts are not general bodies to give justice. Courts follow a procedure. They are very precise bodies which follow CPC, Indian Evidence Act. You can't randomly go to a court and start arguing your case. Courts are very precise bodies which follow proper regulations, proper procedures. Tribunals are generic kind of bodies to solve disputes. Are we clear? Everybody? Okay. And this is a statement of Supreme Court only. So I am simply quoting a Supreme Court statement that all courts are tribunals, but not all tribunals are courts. In the Kyoto Holohan case, 1992, Supreme Court gave this statement. Are we clear now? Okay. So tribunal is a very generic body, actually. So because we already have very precise bodies to give judgments, we wanted some more casual, informal bodies. Okay. So courts are a very specific kind of tribunal. Okay. So this is there. Now, in our country, we did not have any way to create tribunals. Right? In 1976, based on the recommendation of Sardar Swan Singh Committee report, we added a new part called Part 14A through this Amendment Act, and two articles were added, 323A, 323B. Okay, these two articles were added. And what is the content, we'll discuss shortly. Pooja, all the courts are part of tribunals. Okay, please understand, I think two of you are getting confused in the jurisdiction of courts. No, don't go there. Please remain within the basic understanding of what is the purpose of a court. Okay, if you go by jurisdiction, then we'll have to bifurcate courts into Supreme Court, High Court, etc. Then there'll be a complication uselessly. This is a very generic definition given by Supreme Court only, right? A Supreme Court only. Simple. Don't go by again other parameters. The more parameters you add into it, the more complication it develops. Just understand the simplest of this statement, that in general, tribunals are bodies which perform the task of providing justice to people. Courts are those specialized kind of tribunals which follow exact rules, regulations, procedures to provide for justice. That's it. In this sense, courts are actually a very unique kind of tribunals which exist. Are we clear? Now do you understand this? Please remain in this context of understanding of the difference between the courts and tribunals. Don't add unique elements to it, because if you add other elements, then we'll have to further bifurcate. That'll be a problem. Okay. Now, what happened exactly in 1976 was that the parliament made two articles. Mind you, two articles were added. Article 323A was added. And what did this article say? This article said that Parliament, by law, can create a tribunal. By law, meaning what? Simple majority. Can create tribunal. Okay, can create. So in 1976, tribunals were not created. The option was given to create tribunals. Okay. But tribunals for what? Tribunals for administrative matters. What do you mean by administrative matters? I'll explain that in the next slide only, don't worry. And one more article was added called 323B, where it said that Parliament or the state legislature by law can create tribunals for other matters. What is that? Other matters could mean matters of taxation. Other matters could mean matters of environment. Other matters would mean matters of industrial disputes. It could mean various things, etc. Or land reforms, right? Food, etc. Now, coming to Article 323A. Article 323A says that Parliament, if it wants, it can create a tribunal. In 1985, tribunal was created under the provision of Article 323 capital A. So what kind of tribunals were created? We created CAT, C-A-T, at the central level. This was for central government employees. SAT at the state level for state government employees, SAT. And if at any point of time you have a JAT, maybe two states come together to have a common recruitment, which does not happen in our country, JAT can also be there. Now, what will this CAT and SAT do? So let me just clarify now that these bodies are meant for you. All those people here who cleared the examination, whether you become a state government employee or a central government employee, in future you may face lot of problems. The problems could be with respect to your salary, with respect to your pension, with respect to your recruitment, with respect to your transfers, with respect to your promotion, with respect to your retirement. What else? Any kind of problem that you face in your job. If you feel your transfer is not being done properly, it's irregular, if you're not being promoted, if your seniority has been taken away, if your salary is not being given to you, for all such issues, if you are a central government employee, you please approach the CAT. If you're a state government employee, please approach the SAT. Are we clear now? So tribunals are bodies created under the provisions of the Constitution. Clear? (323A) does not allow the states to make a tribunal. Center will make a tribunal for even state government employees. Are we clear? Center will make a tribunal for even state government employees, not the state governments. So SAT is created by the center, CAT by the center. Okay, so let's hope that it does not come to this point, but if in case in future you have any problem, please approach CAT. Like recently, some of our enthusiastic aspirants who did not clearly study properly the prepare for CSAT, they were very unhappy with the difficulty level of CSAT and they had to approach CAT. Are we clear on this? Madhuri repeats SAT. I mean, what's there to repeat? If you have any problem with your state government job, go to SAT. If you have any problem with your central government job, go to CAT. Simple. Are we clear? Prem Kumar will come to that later on. Don't worry. This is the concept of administrative tribunals, which was formed through the law called Administrative Tribunals Act 1985. So, is CAT a constitutional body? No, sorry, it is not. Are we clear? It is a body which is created by a law which is allowed for under Article 323A. Yes, SAT and JAT are also created by this law which is made by the parliament only. Clear? SAT and JAT are made by center only. State legislatures could not create SAT on their own. It has been made by the parliament. Yes, Anurag. All administrative tribunals can be made only by the parliament because Article 323A very clearly says that parliament by law can create tribunals. Nuti Gadi, sir, there are Lok Adalats and quasi-judicial bodies. Then why so many cases are still pending? Sir, population. We are too big a country. Okay. Sir, there is nothing called JAT. So what happens is, every state has its own public service examinations, PSC or PCS. But sometimes it is also possible that two states will come together and say, no, we want to conduct common examination, JPSC. So if any two states have come together to have their joint recruitment, which is not there, then we can also have a JAT in future. Clear? Are we okay, everyone? Sir, UT is a part of center only, sir. Okay? Yes, JAT also by center only. Okay then, great. Now, what is the composition of these CAT and SAT? Very, very easy to understand. You have a chairperson, you have a vice chairperson, you have judicial members, and you have administrative members. What is the qualification? This is the qualification. Okay, one more point. This administrative tribunal is meant for civil servants. Are we clear? It is not meant for combatant services, meaning armed forces. Just to clarify this point here. Not for armed forces. Armed forces personnel have their own tribunals. Okay, that is called an armed forces tribunal. Also, not for officers working in legislatures and Supreme Court, High Court, and lower courts. So, in the courts, all these officers who are working in the administrative department, maintaining the cases, writing records, updating records, those people you can't go to tribunal. Sorry. These are meant only for central government employees and state government employees, not for employees working in the legislature, not for employees in the courts, not for people in the armed forces. Now, in case you want to be a chairperson of any tribunal, very, very simple criteria. You have to be either a current or a former judge of the High Court. In case you want to be a judicial member, you should be a former retired judge of High Court or any IAS officer who has worked for 2 years at the highest level or worked for 5 years at the second highest level in the Department of Legal Affairs. I hope you remember the hierarchy of IAS officers. Let me remind you. Secretary, Additional Secretary, Joint Secretary, Deputy Secretary, also directors in some organizations, Under Secretary. This is the hierarchy of IAS officers. Clear? In every ministry. You will enter here. Chief Secretary is in the state. At the state. State level, it is Principal Secretary and all, difference. I am talking about the central level. Now, third is an administrative member. You have to be a secretary in the government of India or the state government at least for 2 years, and additional secretary for 5 years. In any ministry, that's okay. You are eligible to become a member of the CAT or SAT. Now, the appointment. Let me just clarify here. These are old provisions. Now you will say that, sir, why have you still kept the old provisions in the slides? Did you not update the slides? I paid full money for the course. So before you jump on to all that nonsense, there's a reason why this is mentioned here. Don't panic at all. The few enthusiastic people here. We'll come to that. Why I have still mentioned this, but we'll come to it. So the appointment is done by the president in consultation with the CJI. Consultation, not binding. For CAT and for SAT with the governor. Clear? Term of office 5 years. or maximum age 68 years. This is the tenure, this is the retirement age. Members is this. Then conditions of service, same as High Court judge, same salary, same allowances. Removal by the president after inquiry by Supreme Court. Very, very important. You are removing a person by this process. Very interesting. So far, we saw people like Supreme Court judges, High Court judges, State Election Commissioner, Chief Election Commissioner, CAG. These people are removed by voting in the parliament. There is another process to remove some officials. Same for in case you want to remove UPSC, SPSC members, in case you want to remove members of the Human Rights Commission, in case you want to remove the members of the Vigilance Commission, in case you want to remove members of CIC, SIC, in case you want to remove members of Lokpal, let me tell you, the same process is followed. And what is that? Inquiry by Supreme Court. What is this process? If I have a problem with a member of a tribunal, I'll give a complaint to the president. President will ask the Supreme Court, Supreme Court, I have received a complaint. Look into this. What's the problem? Supreme Court will, through its own procedure, conduct inquiry and then find out whether the allegation is true or not. And then if the allegation is true, the Supreme Court will say, sir, ma'am, remove this person. And the president will sign and remove the person. No voting. No voting. Removal after Supreme Court conducts inquiry. And the same process is used for other people also. I'm writing it here so that you can mug up and remember this in case it is asked in the examination. Are we clear? Consultation not binding. So this is the appointment, etc. Yes, here Supreme Court decision. See, it is not mentioned that it is binding. It is not mentioned anywhere. But if Supreme Court has found that the allegation is true, then the president will remove him. But yes, if you ask me, sir, is it mentioned anywhere that it is binding? No, it is not. But it will be done. Clear? Now, just one small point before we move on. You are a government employee and maybe your salary is being denied to you for the past 5 months. No salary. You're very angry, upset. You're an honest official. Don't take bribes also. Problem. You want to go to the court. Can you go to High Court? You can't. Not allowed only. Not allowed. If there is a tribunal which is created for your problems, you have to go to that tribunal only. Number one. Number two, originally when these tribunals were made, the idea was that high courts are overburdened. We have to reduce the burden on the high courts. What to do? Very simple. Create tribunals. And if a tribunal gives any award, appeal in Supreme Court. That was the original idea of this Administrative Tribunals Act. But Supreme Court in this L. Chandrakumar judgment said that, wait. Are you saying that the award of these tribunals can bypass high courts? No. High courts are court of records. High courts are also constitutional courts. They interpret the constitution. How dare you bypass them? Sorry. Complaint or case will be filed in tribunal. You file a case in tribunal, no problem, but the first appeal will not come directly to Supreme Court. High Court. How dare you bypass the High Court? And second appeal is now in Supreme Court. So in the L. Chandrakumar case, Supreme Court said that, sorry, high courts are court of records. Tribunals awards, sorry, will have to be appealed in Supreme Court, High Court also. You cannot bypass high courts. That is why all the matters which are settled in tribunals, the award can be challenged in High Court also, sadly. Now you may say then, sir, what is the point? No, don't worry on that. Not many cases go to high courts. Very few cases go to high court. But yes, cases do go to high courts. Now quickly, what is the advantage of tribunals? Very simple. Flexibility of procedure. No need for all the drama of evidences and procedures, rules, regulations, hiring of lawyers drama, date after date, nothing. Simple procedure. They provide efficiency due to cost and time effectiveness, saving time, saving money. Otherwise, if I go to court, I have to hire a lawyer, hotshot lawyer, lakhs of rupees per day, per case. Here, nothing. It unburdens the judiciary and also specialization through expert involvement. Experts are made members of these tribunals, which means what? Now more appropriate judgments can be given by these tribunals because experts may have detailed knowledge about that subject, that topic. But of course, with great things, there are some problems also. And one more point, let's not forget, tribunals also have the power to punish for contempt. Just a point I'll write here. Meaning, if you don't obey their orders, they can punish you. Clear? So they'll ask the court to punish you, of course, so they can punish you if you don't follow their orders. Now, what's the problem? Very simple. Yes, tribunals provide for fast and quick justice, of course. But the population is so huge that please don't expect that things are amazing here. Sorry. There are delays in tribunals also. Example. CAT. 17,000 cases. 17,000. Income Tax Appellate Tribunal. 92,000 cases pending. Railway Claims Tribunal. Railway Claims Tribunal. 46,000 cases pending. Debt Recovery Tribunal. 78,000 cases pending. See, sir and ma'ams, this is bound to be there, right? We are too many people. So, of course, pending cases everywhere. Don't ever think that there will not be pendency. Pendency will always be there. Clear? Now, punishments of what type? Fines, penalties are imposed. Fines and penalties are imposed. Mutikadi, without evidence, how will you prove your fact? Evidences are required. Civil only, puja. Second thing, violation of separation of power. How does this happen? A very good example is NGT, National Green Tribunal. More on this in your environment classes. So take the example of NGT. NGT looks into what? Making guidelines which everybody has to follow. Okay. NGT also implements the guidelines. Like legislature, you are making a law. Like executive, you are implementing the law. And like judiciary, you are imposing punishment also. For example, NGT can impose fines up to 10 crore rupees, jail up to 3 years. Are we clear on this? Okay, NGT can send you to jail also for 3 years and fine up to 10 crores. Like in 2017, there was a program conducted by Sri Sri Ravi Shankar. I'm not sure how many Sris are there, but I mean, accordingly. So, Art of Living program on the banks of River Yamuna. So, I'm not sure how this entire event further, cause damage to Yamuna floodplain. It's already very polluted. But this Art of Living festival on the Yamuna floodplains was declared as violating the environmental norms. NGT imposed a penalty of 5 crore rupees. Okay. So, look at this NGT, which imposes a penalty also, implements laws also, makes guidelines also, everything done by one body only. Yes or no? Problem. So, this is a classic example of all LEJ powers into one body. One more thing, just to point this out, NGT is a very unique body in the sense that, let me use this color. Appeal against NGT is only in Supreme Court. NGT Act 2010 says that NGT is a unique kind of tribunal whose awards can be challenged only in Supreme Court. Other tribunals, high courts, NGT exception. Okay, are we clear? Everyone. So you and me, anybody can complain to NGT, right? And NGT will then look into the complaint and find out whether the allegation is true, whether the damage has been caused or not. And if it has been caused, penalty will be imposed on the concerned person. If you don't pay the penalty, then sadly, jail sentence is also there. Yes, polluter pays principle. That if you have caused pollution, you will be the one who will be paying for all the damage. It was this case in 2016 called the Samit Mehta case. MV Rak was a ship which was carrying huge amount of coal, fuel, oil, etc. and diesel. Ship sank close to the coast of South Mumbai. A thick film of oil was formed on the surface of the sea and large-scale damage was caused to the mangroves and the marine ecosystem. You'll be studying about this in your environment classes. Not here. Don't worry. By whom NGT pickup charged? What? Pooja, what is this? Poor culprit will suffer. Poor culprit will suffer? Sir, if he is a culprit who has broken a law, then no rich and poor, please. Don't play the rich poor card every time. It will not work. Haji sir, Prem Kumar, what unique thought do you have now? Guys, let's end our discussion here only today. Tomorrow we'll continue from the same point and I'll discuss other points and then the remaining topic, which is the Reforms Act. And once we are done, we'll enter into the zone of Election Commission of India. That's all for me, guys. Jai Hind. Haji, Prem Kumar. But sir, our